Greetings, my fellow Americans, and welcome to the Great Montana Conspiracy Podcast. Tonight's episode was actually going to be a completely different theme. Kind of similar along the same topic, but as I was researching it, just things went completely afield. I ended up researching another story entirely, and I decided, this one feels far more compelling to me than the original topic. So today, the subject is going to be on false convictions. Yes, anybody who knows my story understands this is an essentially core element of my own life. I'm a political prisoner detained in Montana since 2003 as a consequence of a false conviction brought against me by Flathead County authorities in Montana. But this is so much more. I found a case, and I'm sure a lot of you probably have heard of this particular case, but it brought this issue so strongly and prominently to my mind that I just felt the need to change my direction a little bit mid-focus and focus on the issue of false convictions tonight. Now, before I start, I've used this quote before. Benjamin Franklin said, "It is better that 100 guilty persons should escape than one innocent person should suffer." It's absolutely true. And various historical figures have said variations of it. Blackwell said 10 versus 1. I believe Jefferson also quoted something very similar at one point. The idea being that the principal founding fathers of our country believed very strongly in the idea that innocent people should not be convicted. No innocent person should ever go in jail. If you need to let 100 people who are guilty of their crimes go and to let one innocent person go, that's what you should be doing. We've lost sight of that in this country, not just in Montana, across the country. This is not just unique to Montana. Montana has certainly taken a unique advantage of the environment, but it is a prominent issue throughout the country. And that is the idea that the federal government is just funneling money into the states to maintain the prison system. You've created what's called a prison for profit system. You have Fortune 500 companies, like 10 of them in the top 100 are private prisons. Private prisons are Fortune 500 companies because that's how much money there is to be made in this very lucrative enterprise that the government has created. The federal government wants to incentivize the states to do certain things, to advance certain agendas that the federal government has. The states agree to adopt the laws, and in exchange they get billions and upon billions of grant dollars funneled down to them. It's a problem because you're basically saying we're going to pay you to put people in prison. What democracy or republic or whatever you want to call our country can possibly justify the idea that we need bodies in prison so we can get dollars, so we can get money? It's supposed to be about, did someone commit a crime? Did somebody do something wrong? Did somebody do something that deserves punishment and consequence for their actions? Not, how many people can we arrest this month? How many people can we send to prison this month? How many people can we report to the federal government that we have so we can get money back and do our bottom line and collect money? When you start monetizing and profiteering off of inmates, off of people who are in the criminal justice system, you're bound to get it wrong. More than not. And not just like in my case where it was politically motivated. There are many people, it's just the opportunity exists. And therefore, let's do it. Let's run with it. It's just what it is. It's human nature. If there's money to be had, you're going to have money. Right now, we have a Texas abortion bill. It's actually been held up by federal court. It's been stayed. But in the weeks that it was allowed to exist, they were literally calling it a bounty on abortion clinics. They were basically offered a $10,000 bounty. The state of Texas said, okay, we can go ahead and pass this law, and we're not going to enforce it. But anybody who wants to sue an abortion clinic for conducting an abortion after 6 weeks, we'll let them collect a $10,000 bounty off of them and claim it to $10,000 in court. It was a bounty for anybody to collect across the country. In fact, the two prominent cases that were filed under the law, neither person was in the state of Texas. Literally anybody. I could have done it. I could have filed a lawsuit in Texas to claim money for somebody committing an abortion. because that's how vague the law is. I don't have to actually be affected. I don't have to be involved in it in any manner, shape, or form. It's a bounty. You start paying a bounty to humans, humans will go after that bounty. Now, when you talk about government officials who already have a pre-existing ineptitude towards corruption and looking for money to pad their pockets and their re-election campaigns and their various elite little, private clubs and jet ski lifestyle, or jet set lifestyle, sorry. You have always looking for money, always looking for money. And when you get an opportunity for the federal government to start paying the states for money in order to house inmates, it doesn't take long to imagine before human nature kicks in. And it becomes less, hey, we need help to house inmates, to we need to find inmates to get money. The problem exists when the country is more interested in the numbers of convictions versus whether these are actual criminals that are caught. When you have election campaigns, you have people who pad their, like prosecutors who pad their prosecutorial record. They'll say, I've successfully convicted X, Y, and Z, and they'll just rattle off these numbers and these statistics and everything else. And you don't have, it's about numbers. It's about how many people I've prosecuted and put 500 criminals in prison. Jim over here, that's Jim Bob, is of course the person I'm running against. He's only prosecuted 100. I'm far more effective in my job because I've put away 500 criminals to his 100 criminals. Sorry. At what point does this seem asinine? At what point does this seem to be completely contrary to the focus of the criminal justice system? And of course, as I've demonstrated time and again, you have the motivation and the capacity to abuse the system to put away political inmates, political dissidents, people who don't agree with you, people who want to call out your own corruption, can be thrown in prison because the system is about padding the pockets, and the pockets of corrupt individuals. These corrupt individuals are already entrenched in the system and working to their own benefits. Federal dollars incentivize state incarceration levels. It's just plain simple. In Montana, in 1980, there were 738 inmates. Statewide, 738 inmates. In 2019, there were 4,723. In a period of 30 years, we had gone over 6 times the number of incarcerations. And it all links to the federal government's incentivization of inmates. We will give you money to house them. The crime rate has not gone up in Montana by 6-fold. The prosecution rate has gone up by 6-fold. Because they need bodies, because the more bodies they have, the more money they get. And this isn't even counting the people who are actually in state custody under probation, like myself, probation or parole. These are just the people inside the system. A few years ago, we had statistics released that said that we were the second highest state in the union per capita of incarcerated individuals. Ladies and gentlemen, maybe you don't realize where Montana is or what Montana is. Montana is largely farmland. Farmland and ranch land is mostly open space. It is incredibly rural. We have a few half dozen large communities, but for the most part, the vast majority of Montana is open land. Our population doesn't justify that kind of traffic. We aren't an East Coast, West Coast, high-density, crime-ridden country area. We are an area where we have greedy individuals who want money from the federal government, and so they manufacture criminals so they can put them in prison. And I say they manufacture criminals. I'm not saying they find criminals. They make them up. They run them through an impossible system. It's impossible to beat. The odds are stacked against them. I've already talked about the incredibly high bails they put under, how they hold them way past speedy trial rights. They don't give them probable cause hearings. They make it impossible to overcome the charges brought against them. They ruin their lives. It's an attrition issue. We have the power to throw you in jail and keep you there as long as we want to keep you there. Grants totaling in billions of dollars are funneled from the federal government to the state every year. to the states, not necessarily to Montana. Montana's not necessarily getting billions of dollars, but it's getting a large percentage of that money is being passed down. The only thing that's required to get this money, other than just doing the initial thing, like, okay, we want you to we're going to pass a crime bill in the Congress, and it's going to incentivize the states to adopt these terms. Okay, let's say we're going to do tough on crime. We're going to incentivize the states to make mandatory 30-year sentences on drug issues. Okay, so the states adopt the 30-year minimum. After that, it's on the books. Okay, from now on, you're going to get money every year. You're going to get money. Sorry, folks. So the only thing necessary after the initial, we're going to go ahead and put it on our books and pass this law, is to, which, by the way, increases the amount of time people actually stay in prison, increases the number of people that are actually in prison, and simply gives more weapons to Montana to actually use to put people in prison. And the only thing necessary is to have a physical body in the jail. So long as you have a physical body, it doesn't matter whether the person's actually committed a crime, whether the person is guilty, whether the person is good, bad, other. It only matters if they're physically there. If they're physically in custody, the state gets money. And that's what they're after. They just want bodies in a warehouse. That's all they care about. Getting bodies in that warehouse and keeping that warehouse full so they can continue to get as much money as they possibly can. And if they run out of room in one prison, let's go get another one. In Montana, we actually have 4 prisons, only one of which is state-run. One of the 4. We have a private prison in Shelby, Montana, and we have 2 jails that have turned over part of their beds, their areas of their jail, over to state inmates, and that's Great Falls and Dawson County. So we actually have 4 prisons, only one of which is actually run by the state. Well, I stand corrected. 4 male prisons. We also have a female prison. Which, interestingly enough, you will note I say we have 1 female prison. We don't have 4 female prisons. We have 1. So there's definitely a grossly disproportionate conviction rate there, but that's another topic entirely. But jails, prosecutors, courts, all get this money. The state pays the counties. The counties, it gives money to Great Falls, Dawson County to upgrade or to convert part of their facility over to state custodies. It gives money to, they can pay a private corporation, corrections company to actually build a prison and to maintain it in Shelby, Montana. And of course, it keeps the prison going in Deer Lodge, Montana. All because of this money that keeps pouring into the state just for having physical bodies. And hey, if we don't have enough bodies, we can always create another prison. If we don't have enough beds, we can always create another prison. Or we can expand the prisons we have. Montana has turned this into an incentivized, it has gone from incentivized corrections to manufacturing of physical bodies for profit. It is possibly the worst scenario of the prison for profit structure that exists. When you have that, people are actually being manufacturing crimes, manufacturing criminals. People who've not done anything wrong, they don't care. Let's find a reason to throw this person in jail. Hey, let's do it. Let's do it. Let's do it. Let's throw this person in jail. They don't care if they're innocent. They don't care if they're guilty. All they care about is getting that person convicted, shuffling them out through the assembly line off to prison, or whatever area of the system they want to send them to. We have to. It's like, why not do this? Why not? Human nature. If you have money coming in, let's pad the cells. They are literally hunting for bodies to fill beds in Montana. They're hunting for them. They're actually polling people who are coming from out of state to fill these beds. They don't have enough people in Montana to fill the beds. They're grabbing people who are coming here on vacation or to visit family or everybody else. There's a huge number of people from out of state who are stuck here. There's an old rumor, there's an old joke that goes around that says, come to Montana on vacation, leave on probation. Because you come here and you find yourself incarcerated, facing a charge, and to leave and go back home, you have to confess to a crime just to get back to your job and your life, but you leave on probation. Or you leave after you do a prison stint. They don't physically have enough bodies in Montana, so they have to actually grab the people who come here from out of state just to try to fill their beds. It's an insane system. And, of course, as I said, they get it wrong. And they get it wrong a lot. Because they don't care about the truth. They don't care whether it's good, bad, evil. We're not trying to suppress crime. In fact, there's an entire podcast I want to do on the subject of how the local law enforcement here in Kalispell actually incentivizes crime, actually rewards criminal behavior. Another topic. Maybe I'll do that the next one. Because if I get off on that one, I'll just do another podcast entirely, and I won't get to the subject that I really want to get to. When they get it wrong, you have false convictions. False convictions, as I can personally attest to, are incredibly difficult to overturn. Because the presumption is already there, first of all, in the community that if you're convicted, you're guilty. I was guilty because I was in jail. I wouldn't have been in jail if I was not guilty. I wouldn't have been in jail for 16 months before my trial if I wasn't guilty. They would have let me go. No, that's not it at all. They wanted me in jail so I couldn't get access to my resources, so I couldn't get access to witnesses, so I couldn't get access and prove my innocence through my own resources. They cut me off from them. And then they put me in there for jail for 16 months before I ever saw a trial. And, much like the story I'm going to share, they used a manufactured witness to get me there. The National Registry of Exonerations has records, and those, of course, have records. As of 1989, the registry has recorded 2,872 exonerations with over 25,600 years lost from these exonerations. These exonerations where people have regained their lives over 25,600 or 600 years since 1989. Think about that, folks. Think about that. Our country has been around a couple hundred years. A couple hundred. Collectively, just with these 2,872 exonerations, 25,000 years have been lost to these people's lives. It's absolutely insane. And yet, no one in the government faces consequences for this. No one does. And keep on, this is only the records of the successful exonerations. For every successful exoneration, there's probably 1,000 people out there who are protesting their innocence. Like the subject of today's history lesson. The man's name was Cameron Todd Willingham. On December 23rd, 1991, while his wife left the home to go Christmas shopping, Cameron was left in his home with his 3 children. He had a little girl, 2 years old. He had 2 twins. Amber was the little girl. Carmen and Cameron were the twins, 1-year-old twins. He fell asleep. He woke up. The house was on fire. The house was just an inferno. He tried to find the children. He couldn't. He couldn't breathe. He couldn't see. He felt around for them, tried to find them, couldn't. Managed to make it out, stumble out of the house. Couldn't get back in. The house was too intense. Before he could get back in the house, he was trying to desperately get in there. He tried to break a window, and the house exploded because the air rushed in. As he was trying to break the glass, the house exploded. He was the only survivor, and he lost his 3 children literally days before Christmas. I mean, just days before Christmas. He lost not only his home, but he lost his 3 children. Less than a week after this, the Deputy Fire Marshal, Manuel R. Vasquez, declared it looked like an arson to him. Now, keep in mind, you can't just walk onto a site, look it over, and say, "Yep, it's arson." It requires testing. I have a friend who's actually, it's her profession. She examines arsons, or she has. She's now moved on to another field. But she did for a while. It's fascinating, the stuff that she would talk about, how she can tell flame patterns and everything else. There was no actual evidence of arson. There was none. The information was later discredited after the trial, of course, because it wasn't really allowed to be examined properly before the trial. But because this person, who was the assistant fire marshal, made the declaration it was arson, without any real scientific evidence or real actual attempts to send it to state labs or to have it independently assessed. They just made the declaration arson. Debunked later, but for now we're calling it arson. Based on this allegation, on January 8th, Willingham was arrested, and he was indicted for murder on February 13th, 1992. The DA who oversaw this, the district attorney, was Patrick Batchelor, and his assistant DA, John Jackson, were handling the prosecution. And Jackson is the most prevalent particular person to listen for in this story, because Jackson was basically making sure this conviction happened, and he used this investigation and he used this prosecution and conviction to advance his own political agenda, much like Mark Roscoe in a previous story I told you about. So Willingham went to jail, and while he was in jail, he met another inmate by the name of Johnny Webb, who was a 22-year-old drug addict. And he was in jail for robbing a woman with a knife, and which he admitted he did because he was trying to get money to support his drug addiction. Knowing that the prosecutors knew the information that the actual forensic evidence that they had gathered was not really up to snuff. They knew it had been rushed. They were aware of it. It was a relatively weak case. They were still going to try to spin it to a jury, but they needed something a little bit more. They didn't have a slam dunk. They didn't have the match in Willingham's hand. So the warden, or the sheriff, saw Webb talking to Willingham in the jail, and he immediately pulled Webb out and said, what were you talking about? He passed this information up to Jackson. Jackson said that, he said, this is something we want to watch, we want to encourage. And he encouraged Webb to, now, I'm going to back up a little bit here. I'm going to save that for a little bit later. Webb went on to testify against Willingham at the trial, said Willingham had confessed to him in these conversations, being the two pillars of the conviction, being the forensic evidence, which the prosecution displayed as being inexplicable. He was actually described, he likely drew a pentagram in the middle of the living room as a satanic ritual to kill his children. Webb had testified that that him and his wife had decided they were going to kill the children to cover up physical abuse the children had suffered from the wife, from Stacy. No evidence of physical abuse was ever found on the children. It was just what Webb said at the trial. Based upon the presentation of the forensic evidence, which, as I mentioned, was later debunked, and the testimony of Webb, Willingham was convicted. At the sentencing, Willingham refused to confess to the crime. He was given an opportunity that if he confessed to the crime, he'd get life in prison. If he didn't confess to the crime, he'd be sentenced to death. Knowing this consequence, he still maintained his innocence and refused to plead guilty. And he was put on death row. Willingham was executed in 2004. And after his death, the forensic evidence was debunked. It was found that to be unreliable, should never have been relied on. And Webb actually came back and recanted his story. 22 years. Well, technically, he came back in 2000 and started to try to recant it. But as I will explain in my story, his efforts to recant were blocked by the very prosecutor who incentivized him to make up this information to begin with, according to Webb's information. So basically what's going on is Webb is in jail. He was looking for a deal. Okay? He's looking for a deal. He's like, hey, I want to figure out a way to get a lower sentence. Okay? Anybody who's in jail wants to find a way to save themselves. They don't want to go to prison for 3 years, 5 years, 10 years. They want to save themselves. Now, the problem is that these are inherently dishonest people. You're in jail for robbing somebody at knife point to support your drug habit. And this is a pillar of the community whose reputation should be relied on because he should be believed. I see a problem with that. I hope everybody else does. I certainly do. This is the whole entire system of the jail snitch concept. The snitch is looking for a way out. He's a dishonest person. He doesn't care that he has to throw somebody else under the bus to get there. Webb recanted and made a recording 22 years later for the Innocence Project. And in the course of his recorded interviews, this is the story that came out. He says Sheriff Cotton saw him speaking to Willingham and brought him aside and said, "This needs to be. What are you talking about? What are you talking about with Willingham? He say anything about the murders?" Webb, of course, no. Like, we're just talking. We're in the same cell. We're just talking. No big deal. So Cotton sends this information up to the prosecutor's office. Jackson gets involved, and Jackson contacted and reached out to Webb and urged him to try to get information from Willingham. Webb says he was actually taken to Jackson's office on 4 separate occasions. And in the course of these various meetings, Jackson threw pictures of the dead bodies and the fire and everything else down in front of Webb and said, "Look, this dude is guilty," is the words that Webb used. He said, "This could be your daughters. You really want this man to walk free? This man is guilty. This man is a horrific murderer, and he's going to walk free if you don't give us the information that we can use." He told Webb that his burglary, he was up for an aggravated burglary charge, which, by the way, is a felony as opposed to a misdemeanor burglary charge, which would be a lot less time, a lot less commitment, and wouldn't be a felony on his record. Jackson told him that he could make the burglary charge go away. He told him that even if you're convicted now, I can make the charge go away later. And then Jackson told Webb, "Just say that the fires were started in the corners so we can convict him. Just say he put the fires in the corners. Just say that. Just say that he did that and he told you he did that. Because otherwise, if we don't do this, we have a murderer running around the streets." That's what Jackson told Webb, or according to Webb's testimony. Now, Jackson, just for all sides of the field, has denied this. He claims these conversations never happened. He never incentivized him. He never at any point offered him anything. But also and this is the part that actually has a lot of records to show this did happen. There was a farmer in the area by the name of Charles Pierce. He was a rancher, actually. And he had taken an interest in the criminal justice system and helping young men who had been convicted of crimes reform their lives. He was basically a charitable person. Basically. So Jackson knew Pierce and promised, Webb that, "Hey, if you cooperate with me, I'll put you in touch with this really wealthy rancher who will help you financially and anything else you want to go to school later on. He'll send you to trade school. He'll do whatever you want. Just cooperate. I'll put you in touch with this guy. He'll give you money. He'll give you whatever you want. All you need to do is just cooperate with us." Webb said in later reflection that Willingham never told him anything. His words were, "Willingham never told me nothing." He only testified because Jackson convinced him that Willingham was guilty, and if he didn't do something, a guilty man was going to walk free, a murderer of children. And whether I believe that part or not, he was willing to put a man on death row to get himself out. And as his letters in the years that followed demonstrated, he was well aware of what he had done. And he was trying to milk the system, milk the proverbial golden goose to get further benefits and to continue to benefit from his deal. Pierce had a history of basically trying to be involved in these young men's lives, much more than just, hey, here's a warm bed. He gave them thousands of dollars. He was well off. In 1995, he backed Jackson's running for a judge, which of course he obtained because he was using the conviction of Willingham as a push, saying, "Look what I've done for the community. I put this murderer behind bars." Pierce visited Webb in jail many times, sent many letters, promised to help with testimony against Willingham, promised to help financially if he provided this testimony against Willingham for Jackson. While he was waiting for the trial, Webb took a plea deal and pled guilty to aggravated burglary. After he testified at the trial, that charge was reduced to burglary, though it was a weird system how it was done because the warden of the jail was sent a typewritten letter that said that if you were looking at the record, Mr. Webb's actual conviction is burglary, second degree, not aggravated burglary. That's a clerical error. Please treat him as burglary, not aggravated burglary. And then when years later, Jackson successfully petitioned to have the charge changed. So by 1996, in July 15th, 1996, actually successfully had the charge reduced to burglary. Post-conviction, ladies and gentlemen, and keep in mind, Webb actually went to court at his sentencing hearing and testified to aggravated burglary at the trial for Willingham on the stand. He said he had committed an aggravated burglary and that he had pled guilty to it. But after this trial, after the testimony, that charge got dropped and it became a misdemeanor versus a felony. Jackson continued to advocate for Webb while he was in the prison. He was writing the warden, urging him to get a lighter sentence, urging him to less erroneous custody situations, more benefits, more perks. Pierce deposited over $2,000 into Webb's commissary account. Jackson pushed for Webb's early release, sent letters to the warden, the parole board. Although the early release wasn't granted, it didn't stop Jackson from continuing to advocate for him. In 1996, Webb actually threatened to recant. Then he said, he didn't get out, he didn't get his early release. He felt the deal was not being honored, and he was going back to Pierce and saying, "Look, I'm going to tell the truth because, I'm not getting the deal I was promised." Pierce wrote back to him and told him, "No, you need to keep the deal, because even if you got the media to listen to you and believe you, you're going to mess up our chances to get you out." Batchelor, remember the district attorney Batchelor, wrote that he wanted Webb's cooperation with the Wellington issues while Wellington was still appealing his case. He wanted Webb kept happy. These were in letters that he wrote. So the documentation exists. Jackson, meanwhile, got elected to being judge in 1996, and then proceeded to use that position to continue to keep Webb in line. He went to Pierce, or when Webb got released on probation, on parole, he went to Pierce. Pierce gave him a $10,000 check, of which $7,000 he bought a truck with, paid a $10,000 scholarship, sent $4,000 a month to the school as a stipend for him to live off of, and the school, of course, paid him a $4,000 check. When in August 1990, he was released in January 1998, or on parole, he flubbed that up and went back to jail in August of 98, and he listed on his arrest report that his only income was a $1,000 stipend from Pierce. Even after he was arrested again, Pierce continued to put money on fund his commissary account. In 2000, Webb finally filed a motion to recant his testimony. Ironically enough, it was sent to Jackson, Judge Jackson now, who ignored it, buried it, threw it away. It literally did not end up in the court record. The court docket doesn't show it because Jackson didn't want it heard. Jackson blocked the recantment, and he continued to obstruct any reprieve for Willingham. In the months before the execution, they wanted to have there was enough evidence floating around between the truck that Webb suddenly had and all these other issues that were questionable about where he was getting all this money came up, and Willington's attorneys wanted the opportunity to actually stay the execution so they could look into Webb's financials and find out, because remember, or I guess maybe I didn't, I maybe forgot to mention this point. The prosecutors didn't disclose that they were doing this. They didn't disclose they were offering any financial incentive or deals or anything else to Webb. In fact, at the trial, Jackson asked Webb on the stand, "Did I offer you any deals?" "No." "You said did I say I could do anything for you?" "No, you said you couldn't. Nobody could do nothing." That's what he said at the trial. The circumstances will clearly suggest otherwise. The letters that were written, the documentation of the money, the truck, all of that is a reduced sentence. Bachelor's letters, Jackson's letters, Pierce's letters, all lay it out. There was a deal in place that was not disclosed to defense. The defense was not given the opportunity to cross-examine the witness or to challenge whether his information was incentivized by promises or rewards. By the way, similar thing happened to me. So Jackson blocked the stay. He says, "I don't think there's any evidence that there's anything inappropriate." Why? Because he didn't want his own corruption looked into. He didn't want his own issues looked into, because if you looked into Webb, you couldn't. It wasn't going to take very long to get to Jackson. There should have been a huge conflict of interest here. Huge conflict of interest. Jackson had been the prosecutor of the case in which Webb was a material witness. He should have recused himself. He should have been recused by the people involved. Instead, he was allowed to preside over the case and the issues, buried a recantment from Webb in 2000, and then blocked the stay and allowed Willingham to be executed in 2004. Now, as I've mentioned, this is very reminiscent of my own case. When I was in jail for 16 months without a trial. Didn't have a probable cause hearing. They didn't have a really good case. Sound familiar? Larry Van Alstyne. Look up the name. We just happen to have the same attorney. Edward Gutierrez Falla. Falla, by the way, if you want to look that up. Told him that he was willing to testify against anybody. Just tell him who to testify against, and he would. Suddenly, Van Alstyne has information about my case that nobody else has. It's certainly not on the news. We don't get newspapers in the jail, and the only way he could have gotten it was through either my attorney or my private investigator attached to my case, which were both working for Larry as much as they were working for me. So Larry suddenly has this information. Fire arranges for him to go in and make a statement to the police department, and where he claims that I've confessed. Of course, he's haphazard with his details. Doesn't get the details right at all. But he claimed I confessed. So put back in our general pod, he starts getting nervous. He's getting nervous. Jailhouse informants do not live long in population. They don't, because the inmates do not like rats. If you're snitching against one person, you'll snitch against other people. And I'm not justifying it. I'm not saying it's fair. I'm saying this is what happens. Larry knew he had just made a police report against another inmate. Not only a police report, but a false police report. It's something worse than a snitch. It's somebody who actually makes up the snitch information. So you go from being a rat to being lower than a rat. in jail, in prison, wherever. So he went there, and after a while, after about a month or so, about 3 weeks or so, he decided that he needed to talk to somebody. In the pod, we had someone by the name of Raymond Frank Allen. We all called him Ray. Frank Raymond Allen. We all called him Ray. He was a confidence man. It's the best way to describe it. He was a manipulator. He was all about trying to find angles to manipulate people, to protect himself, and to get things. And Larry decided to confess to Ray what was going on. I did this. I'm scared. I'm worried that Ron's going to find out. I'm worried I'm going to get hurt. Da 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 da. Ray says, light goes off in his head. This perfect opportunity. Because guess what? Ray also had Ed Faya as the attorney. He goes to Ed and says, I want to testify against Glick. Glick confessed to me. Da, 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 da. He takes the information. He goes and gets given a statement to the police. Again, he has access to my personal information. Now, whether he got it from Larry, twisted as it was, or not, I think it's more likely he got it directly from Faya because his information greatly diverged from what Larry had said. So now I have two statements from two jailhouse informants who are claiming to have I have confessed to a crime I've never confessed to because I didn't do it. But their stories are parallel. They're completely parallel. Then they get about a month later, they get called in again to give duplicate reports, and all of a sudden their stories are in line. They're in sync, 100%. Clearly, they have compared notes. They're allowed to go back into population together. They're allowed to talk to each other. Obviously, Ray went to Larry and said, hey, don't worry about it. I've backed you up. So now we're both doing this. So they got together, they compared notes, and came up with a unified story. So when they went back the second time, now their stories were in sync. When it came to trial, they decided to kick Larry to the curb. Ironically enough, he was the one who had the idea to begin with. He's the one who got kicked to the curb because he had a new charge. Well, this is the reason they gave. I actually have a different theory. They said the reason why he was not used as a witness was because he had a new charge and Ray only had a revocation, and therefore they didn't want to give an incentive against the new charge. They wanted to be able to prosecute him properly, and they felt it was easier to work with a revocation than it was to work with a new charge. My opinion is that they didn't want the two up there. They'd already demonstrated that they could go cross purposes in front of a jury. They would tell different stories. They didn't want that to happen in front of the jury. They didn't want to get them on the stand and find Larry embellishes beyond the story that him and Ray have agreed to. Because by this point in time, Ray gets released. Ray got released like a month and a half before the trial to house arrest. Larry's still in jail. By the time trial comes up, these two haven't talked for a couple of months. They're no longer comparing notes. They're no longer, making sure they're in sync. And I think the prosecution knew that they tried to put those two on the stand, they were going to contradict each other. So they chose Ray instead of Larry. For whatever reason they chose Ray. Consequence, I was convicted. Because the jury, it's very powerful for a jury to hear. They don't get told the story of what a jailhouse informant is or what a snitch is. They don't hear that these are honest people who are coming forward and trying to do the right thing, and the jury never hears about they're being offered deals or incentives or anything else. It's always, we're not offering you any incentive, are we? No, of course we're not. No, okay, yeah. You're just doing this because you're a good person, right? You're in jail. You're in jail for actually, in Ray's case and Larry's case, these are not innocent people. There are plenty of innocent people in jail. These two were not. These two were not innocent. Now, mind you, Ray was in there primarily for drinking. Not a big deal. And I'll do an entire issue on another episode entirely on the subject of nexus to crime. But for now, that's the only thing he was in there for. He was drinking and he lied to his probation officer about it. That's all he was in there for. Larry's in there on a new crime for molesting a new child. So, whatever. here we are, false conviction, jury hears this, and they say, this is credible, because this guy is a good guy. He's a good guy who's just trying to do the right thing. He doesn't want a child hurt. Da, da, da. They're after themselves. Webb was willing to send a man to death row, to have him murdered. He was willing to lie because he wanted to gain an advantage for himself. Neither Larry Van Alstyne nor Frank Allen, had any reservation against making up false lies, perjuring themselves in court to give themselves advantage. They didn't care they ruined an innocent man's life. All they cared about was themselves. Core definition of a criminal: self-interest. This whole story is a perfect example of how innocent people are convicted. Not just my own story, but Willingham's as well. There's no concern for actual innocence. All they want is that conviction. All they want is that body. They want that body in jail. They want that check off on their jacket so they can go on and advance at higher degrees. Jackson went on to become a judge. He used that position as a judge to keep Willingham in prison and suppress Webb's confessions, or just recantment. There should have been a conflict of interest. It was overlooked. It was ignored. We need oversight. We don't need government oversight. We need independent oversight. These kind of things are not new. This is not a unique case. This Willingham was actually a very long story. But, and believe me, this is a summation. There's so much more information. I strongly encourage you, go look it up. Willingham is a fascinating case to read. It's a sad case because this is an innocent man. He lost his daughters 2 days before Christmas, and 2 weeks later he was in jail for their murder. And he didn't commit. There was no evidence of arson. None. The forensic evidence was flubbed. They had to manufacture a witness who knew nothing about the case. Nothing. Willingham hadn't talked to him or confessed to him. He just wanted a deal for himself. And he was presented, and the prosecutor was allowed to lie. As a result, an innocent man was put to death. You can't come back from that. You don't get, oh, you know what? Sorry about that. Let's resurrect you from the grave. And sorry about that. We realized we made a mistake. Sorry you had to go in the grave. No, you're dead. You're gone. And it's not just when you're dead. You don't get your lives back. You don't get your years back. I've been a political prisoner since 2004. When I'm recording this, it's 2021. In February of 2022, which the date of this recording, by the way, is October of 2021. So in 4 months, I'm going to have been in this system for 18 years. I don't get 18 years of my life back if I ever successfully overturn my conviction. If I ever get exonerated, if I ever get proven innocent, if my victim doesn't come forward and say, hey, you know what? I lied. I was encouraged to lie. This is why I lied. Da, 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 da. Even if that happened, the chances of my exoneration are next to non-existent because nobody wants to hear it. Nobody wants to overturn convictions. Nobody cares about the innocence. Nobody cares about whether someone's actually guilty. They only care about what they can make the public believe. And of course, they get some money. It's a broken system, it's a broken story, but there we have it. So, as I wrap this up, as I always do, please take the time to read the information blog, support our cause. We are trying to get better equipment. We want to get to a full studio. We want to actually be able to reach out and help other people. We want your stories. Please, by all means, send them in. All the information should be attached to this video. If it's not, please visit me on YouTube, where you can like and subscribe. Information will be there. Or you can visit the original broadcast point, which is monspiracy.podbean.com. I thank you for your time, and as always, please be safe, and whenever possible, please be free. Thank you.